People v. Divine Fredericks.
Good afternoon, Your Honors. Marika Meese for Appellant Divine Fredericks. I'd like to reserve 3 minutes for rebuttal.
Yes.
Mr. Fredericks' detailed and specific request for new counsel raised a serious possibility of a breakdown in the attorney-client relationship that required the court to conduct a minimal inquiry. It did not do so. Moreover, counsel impermissibly
What
opposed—
specific complaints did he make that required the court to?
Okay, so there's really two categories of areas here. One is his communication with his lawyer. He raises the issue in specific facts that his lawyer has denied requests for meetings in person or by video, that his lawyer has hung up on him, his lawyer has been disrespectful to him and his wife.
Did he explain the circumstances, context of the hanging up or the claimed hanging up or the disrespect of his wife?
No, but he did give specific facts, unlike in Porto, where you just have a form complaint where the defendant circled some pre-printed ideas and didn't write anything in the factual space that was provided. This is more like sides. What he's saying
Don't
here—
all telephonic conversations end with someone hanging up?
Well, I think the clear inference is that he hung up on him before—
He wanted the conversation to end.
That
Is
it was
that a specific factual allegation that was even made in this case?
He's saying he hung up on him. The clear inference of that is that I wasn't done with whatever I needed to communicate. And collectively, he's saying, I'm not communicating with my lawyer. And this court has recognized in sides that the communication between a client and a lawyer, trust between a client and lawyer, is central to the attorney-client relationship. So that warranted inquiry. You have a separate series of complaints he makes about his lawyer sort of not fighting for him. He says his lawyer is not working in his best interest. He's making arguments for the prosecution. He's telling him just to plead guilty and not engaging with him in preparing for trial. So that too suggests that there's been a breakdown in communication. Those are seemingly serious complaints that triggered—
generalized arguments that or assertions that have been put forth in a number of complaints about counsel when, for whatever reason, I don't want this attorney. I want another one.
They're not just generalized complaints like you've seen in some other cases. It's specific here. He's giving facts. He's saying—
He's not fighting for me. What does that mean?
Well, he said, referencing the prior court date, specific statements his lawyer made were arguments made on behalf of the prosecution. He is raising specific facts. And it's precisely because the court didn't conduct any inquiry that he didn't allow Mr. Fredericks to elaborate on those complaints. We have, in fact, in the record, Mr. Fredericks' subsequent letters and his grievance where he says, in fact, he was only communicating with the defense investigator. He was never meeting face-to-face with his lawyer or having conversations with him where he was allowed to communicate and talk about his case.
There's a couple of other things that strike me as a little odd about the colloquy and the transcript. You know, I think frequently we've seen defendants who ask for a new lawyer because they're trying to delay things. Since this is lawyer number 4, lawyer number 5, I need a new lawyer, I need a lawyer. My understanding is this is the first time he asked for anything, and one of his complaints is that his lawyer was delaying the case.
Exactly, Your Honor.
Which seemed a little unusual. And the other thing that seemed unusual in the record was that his lawyer says, you know, he's just shooting the messenger, which is an implication. Shooting the messenger, usually, the way I understand that idiom is you're blaming the person who's delivering the message when it's really the message you don't like, but you've transferred that bad feeling to the messenger. The messenger in this case is his lawyer, which at least arguably seems to me that the lawyer has in some way acknowledged that there's this breakdown in the relationship.
I think that's correct, Your Honor. This isn't an 11th hour request made on the morning of jury selection like in Porto or in many of the other cases. This is made over a year and a half before trial. And he's saying, yes, my lawyer, in fact, is delaying the case. He knows I don't want him on this case anymore, and he's delaying it and trying to stay on.
But can't that also go to the seriousness of his complaint? I mean, the people are announcing not ready, and him accusing his lawyer of joining in the unpreparedness of the people. Why can't the judge decide that's not a serious allegation here?
Well,
why shouldn't we defer to the trial court?
It's seemingly serious, and this court has required that the minimal inquiry probe into the very nature of the disagreement and whether it can be resolved. That wasn't done at all here. The court didn't ask any probing questions about what was really going on and whether the lawyer and Mr. Fredericks could continue in a relationship that would work. You have a young man who was facing 50 to life, really serious charges, and if he's not communicating at all with his lawyer, that definitely triggered the minimal inquiry requirement. And there's no way to say that what was done here by the trial court came anywhere near what was required under the minimal inquiry. He had to ask at least some questions, the court, and it didn't ask anything about what was
So
really.
is it because no questions were asked, or because he only relied on the defense attorney? What's your position on that?
Well, it's both, Your Honor. First of all, what the defense attorney said was not really responsive to Mr. Fredericks' complaints, and it was sort of a backhand dismissal of what Mr. Fredericks had said. But the court also asked no questions either of Mr. Fredericks, even after his lawyer had said things in opposition to the motion. He didn't give him a chance to respond. He didn't say, do you have anything else to add? What is really going on here?
I think it matters here in this case where you had a detailed list in long form that the defendant gave him. I mean, because the minimal inquiry is just to apprise the judge of what the breakdown could potentially be, to give them some minimal information.
Right, but
Does the letter here serve that purpose?
The letter said enough to make a seemingly serious request. That triggered the inquiry.
Was the
inquiry,
letter or grievance information before the court at the time that it made its decision?
the subsequent letter that Mr. Fredericks later filed? No, but I think it gives this court an example of what Mr. Fredericks might have said had he been given the chance to actually speak about his complaints. And so you have that in the record, and that's relevant. But what the attorney said didn't really answer Mr. Fredericks' detailed and specific complaints. It didn't address them, and the court didn't ask a single question of either the lawyer or Mr. Fredericks. That was required here. You had to probe the nature of the disagreement, see if it could be resolved. You can imagine the court would have said, counsel, I gave you a chance to discuss this motion with your client. Did you come to some sort of resolution? Are you going to have a way to communicate in the future? Mr. Fredericks, is there anything you want to add? None of that happened. That's not a minimal inquiry under this court's clear precedence. And then turning to counsel's opposing the motion, the court asked him, are you going to adopt this motion? There's here a motion for a request for new counsel. Counsel says, I'm opposing that. There's
Is
no
counsel
way
allowed to explain what he or she has or hasn't done in a particular case, or what they believe the nature of the disagreement to be, so that the court can make a determination? Can they set forth information for the court to make that decision?
I think under this court's precedence, there is a line that is drawn between providing some information at the request of the court about the dispute or alleged ineffectiveness. But here, the court didn't ask a single question. Counsel sua sponte went into this sort of backhand dismissal.
Did
but
the
he
court
first-
have so you're saying that the defense counsel was only permitted to explain if the court said, please explain?
Under this court's precedence, I think so, yes. But beyond that, he clearly said, I'm opposing that. In Mitchell, the lawyer said something nearly identical, saying, I do not adopt the merits or factual assertions. This court found that crossed the
Do we
line.
look at the context in which those words were stated?
I mean, I don't think there's any other context than the court saying, what's your position on this request for new counsel?
Well,
First
he
was
doesn't
out
quite
of-
say that, right? The court asks, are you adopting the motion?
Correct. He
Right.
asked that at the first call. The
Yeah.
lawyer says, I don't know anything about
Right.
it. The court gives an adjournment for him to
Right.
discuss it.
But don't
and
you
then
think
he's-
that's the question that the lawyer is answering? Or is asked to answer? Let's start there.
Sure, but if he's saying, I'm opposing the motion, instead of saying, I'm taking no position, which is permissible, or
Well,
maybe
could he
even,
say, I'm not adopting it? That's what you asked me?
I think he could maybe say no, but to actually oppose it affirmatively makes him an adversary against his pro se client.
So is it those words alone, that's the end of it? It doesn't matter what follows if one deemed it an explanation?
I think what follows makes it even more problematic because he, first of all, doesn't really address the substance of Mr. Fredericks' motion, but to the extent that he does, he backhandedly dismisses it and suggests that it has no merit. That's addressing the merits, that's opposing his client's motion. All of that is prohibited under this court's clear precedent.
He does address it a little bit in that he says, I think, I or my private investigator have met with him any number of times.
He says, I have given him everything. We have gone over this, essentially. But that doesn't really say,
Doesn't he say met with him any number of times, but he doesn't distinguish between himself and the investigator?
no, he says, I or my investigator have gone over this. I guess there's some inference that someone has met with him, but where Mr. Fredericks is saying, I've never met with the lawyer, meeting with the investigator isn't a substitute for counsel. And even if the lawyer does have an obligation to give his advice of the triability of the case, the strength of it, whether Mr. Fredericks should take a plea, is Mr. Fredericks' right to go to trial and his right to testify. And if he said, I want to go to trial, the lawyer has to be able to work collaboratively with him, prepare the case for trial, prepare him to testify. And so it doesn't really address it in any substantive way that would be consistent with what this court has required under the minimal inquiry or what's permissible in describing his conduct in response to a request for new counsel.
Focusing just on the minimal inquiry claim you're making, if we were to agree with you on that alone, what relief would flow? Would your client be entitled to new counsel?
New trial, yes.
New trial, but what about new counsel?
Yes, new trial, new counsel.
If only we agreed on the minimal inquiry and not on the conflict point?
Yes, I think so. It would be a better course, certainly, to, first of all, I don't think that the lawyer who handled this case is perhaps still in practice, but in any event, I think new counsel would be required under these circumstances.
And why not, I believe your adversary argues a remittal would be appropriate. Why not that?
Well, this court has said that a reversal is appropriate. And here you're 6 years later, a trial has already happened, a grievance has been filed, things happened later. It would be almost impossible to go back now and try to recreate that moment of when this request was made. So this court should follow its prior precedent, and reversal and a new trial would be the remedy.
Thank you.
Thank you.
Good afternoon. AD Nicole Nichols for the
What do you
office.
say in this instance about the complaint that there were specific serious allegations made and the court failed to meet its obligation in making the appropriate inquiry?
Your Honor, none of the complaints listed in the letter were specific or seemingly serious.
Was the letter dated?
It was, I believe it was November 2018. And at the next appearance that they had, the court addressed the complaint. But I think it's critical what happened at that moment. The court advised counsel that this complaint that this letter had been raised, it contained a motion for new counsel, and said to defense counsel, take it, review it, go and talk to your client about it, and then come back to me. When they came back, counsel advised the court, the issue is defendant is not happy with the advice they have given him.
Before he got to that, he said, I oppose the motion.
But
Right? That's a term of art. A lawyer knows what they're saying when they say to the court, I oppose the motion. But if I can, it just struck me as odd, the rest of what this lawyer said, because it seems to be both an attempt to respond to the motion, but it is also, as I read it, an attempt to tell the court that there's not much to the defense, right? He wants to kill the messenger, he doesn't like what I have to say to him, or what my investigator is communicating. That strikes me as not going solely to the motion, because the motion is, I am not talking to you. So it's very hard to say you want to kill the messenger, and I've had conversations when the motion is, we're not having those conversations. It struck me that that kind of language is going to the quality of the defense itself.
I would disagree with you on one instance. In addition to the we're not communicating, the letter also says, this attorney is just giving me this advice, he's encouraging me to plea, that is not what I want. So it also goes to that issue.
But that phrase, do you not understand that phrase, that they don't like the information I'm giving, they want to just shoot the messenger? Isn't that more than just about the motion, but about the actual defense itself?
No, I think it is counsel explaining to the court his understanding of the factual issue, that the defendant is not happy with his advice. And
Yes,
counsel...
the advice is going to the defense, is it not?
No, his advice, the defendant has indicated that counsel is advising him to accept a plea, and he disagrees with that. but that falls within the purview of counsel's duty. Counsel must give the defendant an accurate or his interpretation of the evidence and defendant's
Again,
likelihood of success.
isn't that putting to the court?
I'm
that
sorry,
you-
Your Honor?
Isn't that putting to the court that the client has a weak case?
No, Your Honor.
And that is not what our case law permits.
That does not go to
Okay,
the
let's try this.
merit.
Doesn't our case law only permit counsel to explain what they may or may not have done in response to the allegations raised in a motion?
Your Honor, I think two things are being conflated. One, I believe counsel has a duty to explain to the court
What they have and have not done,
Not
not the
just what they
quality
have-
of the defense.
not just what they have and not done. What is the issue? What is the issue that is potentially creating the conflict? And what he said to the court is, the issue is about the advice that I am giving him. And so that, just from that alone, indicates to the court that this is not a seemingly serious complaint, because counsel has a duty to give the defendant that advice, whether or not it's advice that the defendant isn't going to like. Because if counsel doesn't give that appropriate assessment on this case, and in this case, that advice was warranted, because given the defendant's statement, placing himself in with the victim, given the victim's identification of the
Wouldn't you
defendant,
preface
and
that,
given the
wouldn't you
video.
preface that, given our precedent, by saying, this is when I have met with my client, I've met with them X number of times, I've done it over the phone, I couldn't do it in person, but we have spoken in the following ways. Isn't that what you do, rather than saying, and by the way, the content of what I told them is something they don't like?
Your Honor, I think, in Washington, the court has said defense counsel should have an opportunity to explain his conduct. I don't think there's anything
Conduct,
that...
not advice.
No, he doesn't say what advice he's given. He's merely
Well,
indicated that the defendant
He wants to
does
kill the
not like-
messenger, saying it's advice that the defendant is not pleased with. It can't possibly be advice that furthers the defense.
But it's defendant does not like the advice. I think that is counsel attempting to give the court the information without invading into the attorney-client privilege that is so sacrilegious. That counsel is here attempting to satisfy both goals. Give the court information it is required to give, to tell the court, what its perception of the issue is with the defendant. And here, that is given in the presence of defendant. Certainly, if defendant believed that this is not the issue, that the issue is really about the communication, he could have said so. His silence in the presence of counsel making the statement certainly tells us that was the issue. That the issue was he wasn't happy with the advice, and that was the advice counsel was required to give him.
Does it necessarily have to be advice? Maybe he wasn't happy with the plea offer, and the defense attorney says, you know what, he wants to kill the messenger. The people are offering 30 years. He doesn't like it.
Exactly.
Is there any evidence in the record that it was advice?
No, he just said he was not, what counsel says is, you want to kill the messenger, because you don't like the message. It's not clear. Counsel, I
Says
think,
because
is walking that
Just
tightrope.
doesn't like what I have to tell him. That doesn't sound like, just doesn't like the prosecutor's offer.
It is an array of issue, and what he's generally saying is, the defendant is not happy with what I'm saying. But that does not rise as a basis for substitute counsel. It does not go to whether or not counsel can provide competent representation. And there's nothing here that says that.
Would you agree that the court didn't do a minimal inquiry? I'm putting aside the question of whether it had to.
Well, because I would say the minimal inquiry is intended for the court to acquire the information it needs to ascertain whether or not a serious issue would be that may impact counsel's ability to represent the defendant. The conversation that occurred here, while brief, because a minimal inquiry does not have to be extensive, did that. It gave the court the information it needed to permit it to make a decision. And so I would say that this conversation between counsel and the defendant, counsel and the court, satisfies that minimal inquiry because it advised the court was aware of what the issue was, and it was able to conclude that it's not
How
a
does
senior
that, how would that, how would the court's inquiry address the allegation that the defendant's wife was disrespected by counsel?
But, Your Honor, that, again, is not a seemingly serious matter. That does not go to counsels, to whether counsel
I was
can be
asking us to
competent.
put aside the question of whether a serious inquiry was called for in the first place. Sorry, a minimal inquiry was called for in the first place. Was there a minimal inquiry done
As to,
as to the things that the defendant complained about?
well, we only get to that minimal inquiry if it's a seemingly serious complaint.
Absolutely.
And my position is that those other things that he complained about was not seemingly
serious.
serious. To the extent we might extrapolate about the communication that might be seemingly, but defendant did not say his attorney was never speaking to him. That's not what the letter said. What defendant said is he did not have an in-person visit, possibly at Rikers, or facilitate a video conference call. But, you know, each defendant, Your Honor, certainly may want their attorney to see them in person every day and speak to them every day. But that's not the reality. What the record shows is that prior to this appearance, where this discussion is happening, there were at least about 8 prior appearances where defendant and counsel appeared together. And the general practice is that each time before an appearance and typically after an appearance, defense counsel meets with their clients.
So why
and they
didn't
discuss
counsel
the
just say
case.
that? Why didn't that would just be a fact.
Right.
That would just be a fact. It wouldn't be taking a position, and therefore the motion should be denied. It's just a fact.
But that's separate from the whether or not the court can glean from the record if a serious complaint is raised. And from the record, the court could recognize that this, I'm not communicating with my client, is not really reflected. It's not serious. The communication is apparent from the record.
But it sounds like the position, the rule you're sort of advocating then is, however seriously a defendant says, my counsel is refusing to meet with me and hasn't met with me, the court can take a look at the record and see that there have been 5 pretrial conferences where the defendant's been present and reject it without any further inquiry.
No, well, I think the court gives the trial court some leeway because it understands it is most familiar with the trial practice. It's most familiar with the counsel before it, understands whether or not these are, as I said, men of reason and integrity are able to handle the prosecution. But we don't just have that. We have counsel saying, I have met with him, I have spoken with him.
Well, he doesn't
We
quite
have
say that.
provided him
He doesn't
with
quite say that.
discovery. He says, I and my investigator have gone over this stuff with defendant any number of times. I think a fair inference is we have met, we have discussed this. And, you know, we have a full record beyond this, right? And defendant, quite frankly, has indicated in his other motions, he had the discovery. He had provided a list of the discovery that counsel allegedly provided with him. He actually subsequently has stated he had talked with counsel, he had conversed with, he had met with the investigator. All of those things really, I think, flesh out the record and show that counsel was providing the defendant with competent representation.
If this had been right before trial and the defendant says he hasn't met with me to prepare me for trial, would it be different then?
I think certainly closer to trial, the court gets more privilege to deny it without having to engage that
No,
because it might
with
be.
respect to it being a serious claim, I'm getting ready to go to trial, but my attorney hasn't sat down with me. I haven't met with him. It's right before trial. If the defendant's trial is on Monday,
Right.
the defendant is appearing on Friday before the court, making a complaint
Mm-hmm.
that I want a new attorney, yes, you look into issues, is he simply trying to delay? But if he says, I haven't met or prepared for trial, is that not a serious accusation that the court would have to make an inquiry of in a robust manner?
I think it would call for certainly more information if you're saying that throughout our representation, he has not spoken to me about this. It would call counsel
So are you
ability to represent
suggesting
this.
that a defendant can say that my attorney has not prepared me for trial, my trial is on Monday, and there's no obligation for the court to ask further?
Your Honor, what does it mean when he says, my attorney hasn't prepared me for trial? The question is counsel prepared for trial? Does counsel have an understanding of the facts
Doesn't the
and the
defendant
law?
have the right to participate in his or her defense?
Certainly, certainly.
And
Your
how
Honor.
can they do that if their attorney is not communicating with them? You've made some valid points, but you're losing me at, I'm getting ready to go to trial and my attorney doesn't have to talk to me and/or prepare me so that I can make a decision as to whether I wish to exercise my right to testify, give them information as to witnesses,
Right.
et cetera. If that's what you're saying, that's a problem.
No, I am not saying that, Your Honor. I've said that certainly defendant here did not make such a broad allegation that there has been no communication, that he has not been able to talk to counsel. And such an inference it's disputed by counsel's statement that he has spoken to the defendant, he had provided him with information, and it's also belied
Actually
by the
doesn't say
record.
that. He says, I or my investigator,
I don't think that there's a
right? And
substantive
then he doesn't say
difference.
he's met, that could mean he had one communication.
Your Honor, I think the investigator, some of the things the defendant was saying in his letters were geared to the investigator,
But that is
right?
why I asked you the question, whether he needs to talk to, quite frankly, there are assigned attorneys who have investigators go to penal institutions, speak to the accused all the time to get certain background information. But there is an obligation for the attorney to communicate with the client so that the client is prepared to make decisions as to whether to accept a plea, whether to go to trial, and in fact be prepared for trial. That is where I see you seem to be blurring the line.
I think I agree with Your Honor that certainly counsel needs to communicate with his client. And I believe here the record supports that communication occurred. In that when counsel says, I have spoken to him, he doesn't like the message, my investigator has spoken to him, we have met and gone through the discovery any number of times, that there's record support.
Does he actually say, I have spoken to him?
Your Honor, I think that's a fair inference.
No,
from
no, what does he
counsel has said.
actually say?
And I'll read. He says, I and my investigator, John Bruno, have gone over this stuff with Mr. Fredericks any number of times. This is on 812 of the record. And we have gone through everything. And Mr. Fredericks just doesn't like what I have to tell him. I am required to give him an honest assessment of the case. And I think a fair inference is to say, we have met, we have talked, and I believe
And that honest assessment of the case, you don't think that, however, is counsel informing the court of counsel's assessment of the weakness of the defense?
I disagree, Your Honor. That is
see.
just a factual statement of what defense counsel understands the conflict is. And we note that, I
Well,
would say
yes, other than he wants to shoot the messenger. If all he said is, we've met, and I've given him my honest assessment of the case.
I would say, Your Honor, that other record reference, that the very fact that defendant says that counsel hung up on me suggests that they were having conversations. But he may not
Hung
have
up on the
liked what they
wife.
were
I thought it was
having.
hung up on the wife.
I believe he's, I would look at the letter, but I would say he
Maybe
believed,
you're right.
he said the both of them. But just to briefly address, Your Honor, as to the conflict, I think the counsel's use of the term "I oppose" cannot create a conflict. That is, mere verbiage that counsel may have used to just speak about whether or not, he's.
But it may be an artful, perhaps.
It might be an art form, but I don't think it gives any different information than when counsel say, I don't adopt the motion. It really, it elevates form over substance. It says the same thing. What we need to look at, and this court has always said we look at the context, is what counsel says afterwards. Does he take a position that's really adverse to his client? And as we've discussed, I don't think that happened here, that all counsel did was given an outline of the conduct he took on behalf of defendant that's responsive to the complaints the defendant said. And he did not cross the line that this court has set forth. And just to say, defense suggests that counsel can only provide that information when asked by the court. And I think that would remove from, Washington says, counsel should be given the opportunity to speak on his behalf and to say, what he has done. And to say that that can only be done if asked a direct question, I think that would give a right with no substance to it. And that really, counsel should be able to speak, whether it's directly by the court or not. And what we need to look at is what counsel said. And here, we do not believe that counsel created a conflict by his statement, and that defendant did not identify a seemingly serious question that required further inquiry. I don't know if the court has any questions about the defendant's last claim about the 440 motion. I would just briefly say that the court here, I apologize, that defendant proposed rule that, every pro se motion should be inferred, a question of fact is raised, and that should have a hearing, that rule is inconsistent with the mandates of Article 440, which anticipates.
I thought that in their reply, they disclaimed that they were seeking a per se rule. I didn't understand, I thought they said that's not what they were doing.
That was my reading of it, that they may have said that, but what they've argued is that if it's a pro se motion, it should be presumed to raise a question of fact and should require them to get a hearing. And I think this is in absolute conflict with the language of 440, which contemplates that, before a hearing is even granted, a defendant is required to meet a minimum burden. Defendant did not do that here. He raised no question of fact, and therefore a summary denial was a prudent exercise of the court's discretion. And to have hearings where there's no question of fact would merely just place a burden on trial courts
Does
unnecessarily.
440 require that he get an affidavit from his lawyer?
It does not, Your Honor. And really, all that happened here is a
Or even
defendant.
explain why he couldn't?
440 requires that their claim be substantiated. And he could substantiate it through a question for an affidavit from counsel. He could have substantiated by his own statements of personal interactions with counsel. All the court really did here was say, you did not substantiate this claim. You didn't, and it's a very low burden. It's not saying that you must have the affidavit. All it asks is that you reach out to counsel and ask if counsel will provide an affidavit. If he does not,
If you filed a grievance, what would be the point of that?
I apologize, Your Honor.
If you filed a grievance, why would you be reaching out to counsel to support your claim?
Your Honor, it's to merely say you might file a grievance. That doesn't mean that counsel would not respond to the motion. And we note, I would note here that defendant did file a grievance. The grievance did not find any issue with counsel.
I understand.
But critically, he did not include counsel's response to his grievance complaint. I think the absence of that is telling. But what I would say is defendant does not have to provide that complaint. He could support it in other ways. Here, he did not provide that support or any support. And so all we had here was the court simply applying 440 and the precedents of this in other courts.
Thank you, counsel.
And we ask that you affirm. Thank you.
Counsel,
Mr.
if I
sorry.
can, on the conflict
Yes.
argument, you're relying on the statement, I'm opposing that. Anything else?
I'm also relying on what he said afterwards, without any question by
Specifically-
the court, where he, instead of laying out what he did, I met with Mr. Fredericks on each court
Right.
date. I've had calls with him.
Specifically, where he said, you mean, don't shoot the messenger?
Yeah, he's shooting the messenger. He doesn't like what I have to say. That's not just explaining what he may or may not have done in the case. That's not explaining his conduct. That crosses the line because he's saying, he's opposing the merits there, and that's impermissible under this court's precedent. And I'm opposing that as well, his starting words. There's no way to interpret that other than as an adversarial statement.
You point us to Mitchell, where I think counsel says perhaps a little more than here, but are there any other cases that you would point us to where there is, a similarly you might disagree with the characterization, but I'll say brief exchange that gives rise to a claim?
Well, Mitchell and the companion case in Mitchell, there were actually two cases in that, and in each of them, counsel said something more along the lines of what counsel said here, and this court found that impermissible. In Mitchell, it was, "I do not adopt the merits or factual assertions," and in the companion case, it was in regards to whether the plea had been coerced, that the plea was knowing involuntary, taking a
But
position.
those are the most on-point cases from your point of view. That's what I wanted to understand.
Yes, certainly cases from this court, and I think they're directly applicable here and show that what counsel said, including his direct opposition and everything afterwards, that was not the kind of permissible explaining his conduct that was found in Washington or any other case. And returning just briefly to the seemingly serious request, it was made here a year into the case, and the case was on for trial. So going to what Your Honor and Judge Chapman said about the timing and whether he's communicating, you have to look at everything he said, not just the one complaint, and if that makes enough. Altogether, he's saying, I'm not communicating with my lawyer. He wants to go to trial. The case is on for trial that day. It's still a year and a half until the ultimate trial is had. He's only communicating with the lawyer, and counsel never, in fact, said that he had spoken with him or met with him. He gives this sort of generic thing about he and his investigator, and so, yes, that is a seemingly
What
serious.
about when you say we've gone over it?
We don't know what they went over. I mean, because Mr. Fredericks said a lot of things. So what is it that they went over?
But if he went into the particulars of things I reviewed with my client, wouldn't that more readily support a claim that he's spilling out into the public privileged information and undermining the defendant's defense?
Yes, that could be problematic, but he could still have detailed, here's what I did. I've met with my client each time the case was on. I meet with him down in the courthouse in the pens. He doesn't have to go visit him at his jail facility. That's not required. But is he having meaningful conversations? Is he allowing his client who's expressed a desire to
So your
participate
argument is
in
that
his-
he needed to affirmatively assert that he in fact did so?
He could provide facts about what he did that the court can then use to decide the motion. And of course, the issue here is not whether it rose to good cause, but simply whether the minimal inquiry was required. And it was here, and it wasn't done. Just turning briefly to the pro se motion for the 440, if I may. The court denied it for his failure to get an affirmation from counsel or explain that failure. That failure could not have been more apparent to this court. Mr. Fredericks asked for new counsel at the sentencing proceeding. He had filed a grievance. He provided those materials to the court to show that he had done that, requiring an additional statement, a sworn statement. I tried to get a letter from my client, or I tried to get an affirmation.
Did the defendant have counsel's response to the grievance?
I'm sorry, Your Honor?
Did defendant have counsel's response to the grievance?
I don't know whether
No, I don't know if you know.
I don't know whether or not he did, but he submitted at least to the court that he had filed a grievance to explain, obviously, that he and his lawyer weren't communicating. And then the issues that he raised are including that counsel failed to prepare him for trial, failed to impeach the detective, failed to call an alibi witness. Those required information from counsel, and that was the factual dispute, to decide whether or not there was a strategic reason. There's no way that that didn't create a factual dispute that warranted a hearing, and summary denial was inappropriate. Thank you.